Now let us talk about what is the need for investigations of companies. Since the shareholders themselves are unable to supervise and ensure efficient functioning of the companies, the organized supervisors by government agencies assume significant role. It's only efficient and smooth functioning of the corporate that can ensure an adequate return on capital invested by the shareholders. And this need was explained by the Supreme Court in Barium Chemicals Limited case. In Barium Chemicals Limited, the Supreme Court has observed the elementary philosophy of the Companies Act is to trust the shareholders for ensuring efficient performance. But for reasons more than one, the shareholder, they have already receded to the background. Firstly, he is an investor who for the most part does not wish to be bothered except for dividends. Secondly, due to great diffusion of stock, shareholders become indifferent to voting and controlling. And thirdly, the shareholders are ill-equipped to challenge the wisdom and experts of officers. Fourthly, for shareholders have the means or ability to act against the management. If we can take a quote from Freund. He says, the reality of control can only be found in the action of public opinion and in the organized supervision exercised by government agencies. Hence, this is the importance of investigation. That is why we are doing this module, and that is why the Companies Act has provided for all these provisions. Thus, the provisions for investigations, they help prevent corporate abuses as well as wrongs and ensure efficient functioning of the corporate managements. If we compare inspection and investigation, first I'll talk about inspection. The registrar is empowered to carry out inspection of the books of accounts and other documents of the company, where on a scrutiny of any document filed by a company or on any information received by him, the registrar is of the opinion that any further information or explanation or any further documents relating to the company is necessary. He may by a written order require the company to furnish in writing such information. This has been provided in subsection 1 of section 206. If the information provided by the company is inadequate or, in registrar's opinion, unsatisfactory state of affairs exists in the company or does not disclose a full and fair statement of the information required, he may again call on the company to produce such books or papers. The provision is there in subsection 3 of section 206, and after fulfilling this procedure, the registrar may carry such inquiry as he deems fit. It's there, 206 subsection 4. The central government may authorize any statutory authority to carry out the inspection of the books of accounts of a company or class of companies. 206 subsection 5 talks about it. For carrying out on inspection or inquiry, the registrar or inspector shall have powers of a civil court in relation to the matters as has been prescribed under subsection 3 or section 207. The registrar or inspector shall submit a report to the central government and recommend, if necessary, further investigation is required into the affairs of the company. Further, the registrar or inspector may enter and search the place or places and seize such books and papers if he has reasonable grounds to believe that such papers as mentioned are likely to be destroyed, mutilated, altered, falsified, or somehow they have secretly deposited somewhere. No company or member can ask for a copy of inspection report. The expenses of inspections are borne either by the government, and these are not recoverable by the company. Section 225 provides for it. And if we compare inspection and investigation, so let us talk about the procedure of investigation first. On receiving the report of the registrar or inspector under section 208 or on intimation of a special resolution passed by a company or in public interest, the central government may order an investigation where necessary into the affairs of a company. The central government may appoint one or more persons as inspectors to investigate into the affairs of the company, and no firm, body corporate or association shall be appointed as inspector. Further, the central government shall establish an office which would be termed as I told you in the introduction, SFIO, that is Serious Fraud Investigation Office, to investigate frauds relating to companies. It is a multidisciplinary organization consisting of experts from various fields. If we name banking, law, corporate affairs, they may be experts in taxation or information technologies, and further the details are provided. The directors of SFIO may designate such number of inspectors as he may consider necessary to investigate into the affairs of the company. Where any case has been assigned to SFIO, no further investigation order of agency of either central or state government can investigate the same case. The officer designated shall have the powers of an inspector as has been provided under section 217. SFIO shall conduct the investigation in the matter and follow the procedure as per the provisions, and he is going to submit his report to the central government within the specified time period. The central government may demand an interim report of the investigation. The director, additional director or assistant director of SFIO may arrest any person who he believes is guilty of an offence punishable under the section. Such person arrested shall within 24 hours be taken to a judicial magistrate or a metropolitan magistrate who has got the jurisdiction. A copy of the investigation report may be obtained by any person concerned by making an application in this regard to the court. Section 212, subsection 3 can be referred for this. The expenses in the first instance shall be defrayed by the central government but may be reimbursed partially or fully by the persons as prescribed under section 225. Let us talk about the rights of bail of persons charged and arrested guilty persons. Section 212 subsection 6 to 10 provide for it. They deal with the procedural aspect. The offences specified under various provisions of the Act that attract punishment for fraud under section 447 are to be cognizable offences. The persons accused of any such offence shall not be released on bail or on his own bond unless the public prosecutor have been given an opportunity to oppose the application for such release. The court is satisfied that there are reasonable grounds for believing that he is not guilty of such offence and that he is not likely to commit any offence. However, the following may be released on bail if the special court so directs. If the situation is that the person is below 16 years of age, it's a woman, or somebody who is sick or somebody who is frail or infirm. The special court is not to take cognizance of any offence except upon a complaint in writing made by the director or by the SFIO investigating officer or any other officer of the central government authorized by a general or special order in writing. These limitations of section 212 subsection 6 are in addition to the limitation as have been provided under the Criminal Procedure Code 1973.